Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Today we're going to be talking about divorce and family law. We're going to talk about a couple of different topics, and then we're going to take some questions from viewers that we received over the last several months. Joining me once again is my co-host, Jesse Barrientes. Jesse, how are you, sir?
Very good, Dave. How about yourself?
Good to see you.
You as well.
How are things going?
Things are going fantastic. I know we just had a wonderful show on real estate because right now we're in that time and and just kind of plugging along here. It's great to be back on the show.
Yes, and unfortunately people have to sell real estate sometimes when they're going through a divorce or a marital breakdown of some sort.
Right.
And let's talk briefly about the two different types of divorce cases that you find out there, the uncontested and the contested. They're often confused.
Right.
Give a little background on the two, if you would.
Well, let's say, I mean, there's really no such thing as an uncontested divorce because it's divorce. But it's when the people are already in agreement, and there's a lot of different vehicles that people can avail themselves of, like collaborative law. They can work everything out first and go to mediation and do all wonderful kinds of things and save some money so that, hey, listen, when they go into court, all the documents are drafted, they're in agreement with respect to custody and with respect to parenting time or visitation, with respect to the distribution of property and everything else. So now they go in and they're out. They file it, they get their proof update to conclude it, and they're done.
Well, wait, if they can work it out so well, why don't they go to counseling? Maybe they could save the marriage.
Well, I always tell people when they first come in, we always try to explore whether or not the marriage is truly dead, whether or not they have counseling, or whether or not they want to participate, but it takes two. Generally, I find that there's one person, or that they've already tried before, or that one person wants to go to counseling, but the other person doesn't want to work it out. And to me, that's really important. If you can, you can. And so we just want to make sure that, hey, that's what the person wants to do. But realistically, if it's over and there's nothing you can do about it and that's the way it goes, why not be smart about it? And hey, this is what we do for a living. I certainly don't mind getting paid, but let's be smart about it because that's taking money. The more you contest it, it's taking money away from you and from your children, if you have any, and everything else. So that's the contested.
Well, that's good that you encourage counseling. There is one county surrounding Chicago that won't let you file or won't let you actually get a final decree in divorce until 30 days have passed since the filing. And I believe that's an old carryover from the Christian religion to encourage marriage and not to encourage a dissolution. Do you agree?
I agree. It's a death. A divorce is a death. That's what it is. And hey, especially if you're Christian, right? It's for better or for worse till death. And hey, you have an obligation. It's too easy. If it was as hard to get married as it was to get a divorce and expensive, people might not do that. They treat it like it doesn't matter, it's not important.
Right. But there must be a reason. You have to have grounds. You can't just wake up one day and the two parties say we don't want to be married and go to court. There has to be at a minimum for irreconcilable differences, a 6-month separation.
Right.
Or you can use other grounds where there is no time frame, but you can't just walk to the courthouse, fill out forms, and get a divorce without having grounds or a justification for it.
Right. There has to be a reason, and you have to prove that reason.
I don't love you anymore.
Well, that's the reason. Hey, it's all over. We just can't get along. That's what the reconcilable. Illinois is a no-fault state.
I saw Sandy at work, and I like Sandy now.
Well, I mean, hey, that's too bad. Good luck.
Or your example, I went out for milk
and never came back. Yeah. And then you have the contested divorce, and again, all divorces are truly contested. That means that neither party are in agreement,
or there's just one thing possibly holding it up. Maybe they agree on everything except who gets the house.
And if that's the issue, then again, that's something that I would encourage people to go to mediation. I'm a mediator in DuPage, and Gardner Lighton, which is an attorney who, when appointed by the court, does an investigation and make a recommendation to the court on what the best interest of the children are. But I would recommend, if that were the case, that you would go to a mediator because you're going to save more time and a whole lot more money if you do it that way to try to resolve that. And if you can't, you've tried. But it's going to get a whole lot more complicated. It's going to be emotionally troubling, and it's going to be expensive when you go that route. I just want our viewers at home to know this too. We do a lot of shows on bankruptcy and divorce. And why is that? That's because what's prevalent out here now, because of our economy and because of the way things are, it's bankruptcy and divorce. Our whole purpose here is to make sure that our viewers at home are advised and that they kind of have an idea of what to look for and what to ask for, and so that they're educated. And so that's, I think, what we're trying to do in terms of making sure that they're equipped when they have that kind of an issue or situation.
Yeah, you also want people to have realistic expectations. You
Right.
want them to know a little bit about the parameters of how this works. It's not going to be one side dominating the other anymore. The courts will not necessarily let one party run roughshod over the other. They want to do equity. They want to make sure it's not unconscionable,
Right.
the agreements that they enter into. But there's a lot of places someone can go for information. There's websites, there's books, there's a library, there's the ICL, which is a legal publication on this. People can read up about it, but really, most people want to be handheld.
Well, but you can read up on it, but it's different, okay? If all you need to do was to read up on it, you wouldn't need the lawyers or the judges, right? I mean, this is what it says, but it's not. It's
some people
difficult
would
to
argue
say.
they don't.
Right? No, that's true, but it's not what it says it is. There's a whole body of law and case law and legal decisions that interpret what the statute says. That's one of the areas. No more than I would go into a heating and cooling place and try to fix my furnace or try to fix my air conditioner. I don't have a clue what's going on, and the same is true. You want to get somebody who knows what they're doing, somebody who does a substantial amount of that type of work to be able to guide you along. And let me tell you this, a lot of people, they go to their friends and they ask. And friends are great. That's a great place to start, or family. But here's the problem a lot of times. I get people, they come in and say, well, this person said that they got the house and the car, all the bank accounts, they got custody of the kids, and their spouse doesn't have visitation, and that's what they want. And you know what I usually tell them is to let their friend represent them.
Right.
But
Right.
again, each situation is unique and it's different, and it not only depends upon your situation, it depends on where it was filed. It depends on which judge that you have. And so it's also important to get an attorney who's familiar with the judges in that particular division.
Right. And it's good to know the basics, contested, uncontested,
Oh, yeah.
but you need a professional who knows the details, which leads me to our first question.
Yes.
Kevin from Stager in Cook County says, I'm considering fighting for custody. What is the best interest of the child standard that he keeps hearing about? Best interest of the child standard, what is that?
The best interest is, again, they're looking at what is best for the child, because realistically, it's all about the child. And
So it's not what's best for mom or dad.
No, and this is what, and again,
That's the confusion.
That's confusion. In some of the mediation sessions that I have, one of the things that we go over quickly, because if there's an issue with custody or visitation, all of the counties are going to send you to mediation in any event. It's court-ordered mediation, and you have to be there. And there's nothing like getting two people who hate each other, who don't want to be there in front of you, and you have to help them along to try to come to terms to develop their hopefully a solution. And the mediator is in charge of the process, and the parties are in charge of the outcome. But the best interest, and I tell people all the time, would you do anything? Do you love your kids? Of course. Who's going to say no, Dave?
Right.
I sure hope not. I mean, they're your kids. You love them. Are you going to do anything for your kids that you believe is best for them? Oh, of course. Even inconvenience yourself, because it becomes, well, wait a minute. I want to do things this way, or I want to pick up at this time, or I want you to drop them off, or I don't want to have to come back. All those are me, I. It's not about you or your convenience. Listen, the child or the children are blameless in this process. It's between you and your spouse. Okay, things didn't work out. You tried counseling, or maybe you didn't, or you didn't want to. And hey, don't don't damage the children any further because you want to make things more convenient for you, because you don't want to come back another half an hour to be able to drop them off or to pick them up or to do whatever. Shame on you. It's not about you. It's about the children. And so the court is going to look at what is best. And sometimes they'll appoint a GAL, I was talking about it, I'm a guardian ad litem, or what they call a 604B custody evaluator, which is much more expensive.
Yes.
And there are psychological tests involved, and all the parties will go to that person, and after 3, 6
scary.
months, well, it isn't. What's scary about that is the expense. It's going to cost you a ton of money to do that.
Right. Or what in the law doesn't cost a lot?
Well,
Try getting a DUI and see how costly that is.
But here, this is what I tell people too. Here, you know what? Spend the couple $100 for the cab ride home or for the hotel room.
Right.
But hey, all you can do is advise. If they don't listen to you, what are you going to do?
So in your mediation,
Right.
if you're appointed, will you explain that best interest standard to the parties, or do you leave that to the court?
Well, generally, it's not my job to explain the law, but sometimes, it kind of crosses because they have to have an idea on what it is. And, what we'll do generally is look at the pleadings and kind of see what's going on. And, again, to see what's really truly in the best interest of the child. Now, if you have someone, a spouse who is working 24/7, 365, and a spouse who can make his or her own schedule, or who's at home, let's be realistic here. Is it better for me to have the children and have somebody else watching them? Or is it better for them to have mom or dad be with the
Well,
children?
sometimes one of the parties doesn't want to pay child support, so
That's
they're
true.
pushing for custody, knowing darn well
Right.
they couldn't handle it, first of all. They don't have the time commitment. They have to work, but they don't want to pay child support.
Or sometimes
So
people
the fight
want
goes on.
child support. Sometimes it's on the other foot there. But here, and let me tell everybody in our viewing audience right now, all right, you have an unmitigated obligation to take care of your kids. I don't care if you're just starting off in the process and you've left and there's no order, there's no paper requiring you to pay support. Those are your children and that was your spouse. You have an obligation to take care of those kids.
You hope they're your children.
Well, I mean, that brings up, we've had a lot of interesting things, but
Petition to establish
Right.
paternity or to establish non-paternity.
But if the child is born during the course of the marriage, it's presumed, there's a presumption that it's a child of marriage. But
Those are
again,
rebutted.
Well, it can be. If there's an issue, then you could get into that in terms of litigation. But those are your kids. Take care of them. Those are your children. All right, take care of them. So that's my. I don't know if we answered the question there, but
We did. Lindsay in Blue Island, let's get another one for you here, Jesse. I want joint custody of my son. Why is this so hard to accomplish? I just want to have a say in my son's life.
it's not hard. Generally, it's a label. Joint custody. Well, here, there's joint and sole, and then there's some variations on custody. Joint custody essentially means that the non-custodial parent, the parent who doesn't have physical possession of the children most of the time, has a say-so in the upbringing of the children as it relates to their education, as it relates to their medical, and as it relates to their religion. Now, generally, if the children are, 3, 4, 5, 6, in that age bracket, most of those decisions are already made. If you're Catholic, then generally, you're going to church, or if you're Christian, you're going someplace, and that doesn't become an issue. Medical is obviously, it doesn't apply to emergency situations, because if something happens during your parenting time, well, of course, you call the ambulance, you bring the child to the emergency room, or you do whatever. That's a little different.
Education is a big one.
But we'll get to that. But when you talk about, orthodontia or things that are elective, those are the kind of things that you need, because they're expensive, so you need to talk about them. And that's where you have a say-so. And then education is very important. Not just, and I'm not talking college, that's a whole other thing.
Public, private.
Public, private, that comes up all the time. Who doesn't want, and again, best interest, who doesn't want their child to have every advantage? But I can't send you to the private school, Dave, that's $100,000 a semester, because we just don't make that much. However, you know what? We might be able to do something else.
And you might already be paying real estate taxes to support the public school.
That's true, and depending upon where you're at, we have a lot of great public schools. So yeah, that's the only difference. In sole custody, that just means that the person who doesn't have, is not the residential parent, does not have say-so in those 3 areas. It's just, people can't get over it. It's just a term. Now, it's nice to have a say-so, but joint custody is only available for those people who can get along as it relates to the children. If you can't get along, forget it. There's no point in it. And let me tell you what usually happens. Usually happens, people do joint custody because they want to resolve things or anything else, and then the person who has joint custody, the non-custodial person, generally doesn't really have an input, and that's how it goes. And then sometimes you have situations where the custodial parent tries to act like they have sole custody and they just make unilateral decisions. But anyway, that's kind of the skinny on that. Let me ask you, Dave. There's Christina in Midlothian asked, it says, how do I know if my case is going to be contested or not? We talked a little bit about contested, uncontested earlier, but how do I know?
Well, I think the best thing to do is to talk to your spouse, get an idea. I mean, obviously it's a very tough topic to talk about, and some people can't do it, but if you want to get an indication of whether your case is going to be agreed upon or not, you have to sit down and have that conversation with your spouse and see where they're going with it, whether or not they're going to be amenable to sitting down and working out an agreement, going to maybe one lawyer, even though that lawyer can only represent one party. If everything's in agreement and there's not much there, maybe that one lawyer can handle the case and the other can just sign on their own pro se. So you have to have that conversation with your spouse to find out where their head is at and what they're thinking, and whether or not this is going to be something they can resolve amongst themselves.
And if you have one of those issues, we talked earlier about going to mediation. Doesn't have to be court appointed, but if you go on your own, and there are mediators, accredited mediators, to help you with that. But what happens, Dave? Wait a minute. I'm afraid that if I tell her that she's going to take all the money out of the bank, that she's going to call the police and say that I hit her to get me out of the house. I've heard horrible stories from other people about those things.
Well, if you have that kind of spouse, you're not going to have an uncontested case no matter what. So you better plan accordingly. Seek counsel of your own. Have a petition filed. Your spouse will have 30 days to respond after she was served or he was served, and then it will litigate through the courts. And if that includes discovery, interrogatories, requests to produce, depositions, maybe there's a business that needs to be evaluated, maybe there's multiple properties, who knows what's involved, but you're going to need counsel if you have a spouse that you feel is going to do something wrongful towards you. And cleaning out the bank account, falsely accusing you of a crime, those are serious, serious violations of ethics. So you definitely want to remove yourself from that situation and get good counsel.
Well, let me ask you another one, Dave, because it's kind of similar. It overlaps a little bit. James in Naperville asks, what's the average length of a contested case with no children?
All right, well, it's going to depend on the county. It's going to depend upon the parties and the court system. But let's just take Cook County, for example. A contested case can range anywhere from a year on the short side to 2 years or more on the long side. It really depends. It comes down to reasonableness of the parties, the willingness of not only the parties but the attorneys to try and bring this case to an end. A lot of attorneys are just churning cases, and they're not interested in settling them. They want to continue it. They're making money. They're maybe not doing their due diligence. So it really depends on a number of factors. But I would say anywhere between a year and 2 years in Cook County. What would you say in DuPage and Will?
I'd say that's pretty accurate, kind of depending upon what it is. There are a lot of judges who will put your case on the fast track. There's nothing like settling a case by setting it for trial.
Right, but to get to the point where they're going to set it for trial is a long time down the road.
There's a lot of stuff, and again, it depends upon those other variables and complications, like you said, whether or not you have to do a business evaluation or something of that nature.
Okay. Terry in Joliet, Will County, wants to know that what he can do, because visitation under the judgment, so he's already divorced, has gotten very difficult. What recourse does he have against his ex?
Well,
can't see the kid, Jesse.
Right, you can't see the kid. If it's difficult, I mean, that could cover a whole bunch of different things. But
no, he's being shut out.
If it's a situation where you have court-ordered visitation or parenting time, then you could go back into court and the way you enforce a court order is by what you call a rule to show cause. You file a petition for rule, meaning that, hey, listen, you're telling the judge, look, here is this order, and it provided for A, B, and C, and the other party didn't do A, B, and C, and that person's refusal to do A, B, and C is willful and malicious, and it's contrary to this court's order. And then the court will issue what they call a rule order, which will set a specific time to do a hearing and for that person to come in and show cause to the court why he or she should not be held in contempt for failing to obey that court. Now, this is very important. Different counties are different. Generally, when you bring a petition, you have to be able, you bear the burden by generally a preponderance. There are other situations that require a different standard of proof, but generally by a preponderance of the evidence, which is more likely than not. But when a rule is issued, the burden now shifts to the other party. That's key. Now, all counties don't have it. Some counties it doesn't matter. So, it doesn't matter if a rule is entered or issued or not. But that's what he can do, and then the court will decide. Or if it's a situation where, hey, listen, visitation because it's not working out because I've changed jobs and my schedule is different. Now I'm on a split shift or I'm on a different shift, and my former spouse doesn't want to cooperate with me to do that. No, we're just going to follow. This is what it says in the judgment. This is what we're going to do. Okay, that's fine. Well, then you can file a petition to modify your visitation or your parenting time based upon that substantial change in circumstance, which would be, hey, listen, you got a new job or your situation has changed so that you can't exercise the visitation that you had.
Okay, this going back into court, though, that's going to create an expense unless the party's able to do it on their own.
And let me tell you, what do you think is going to happen when you go in?
The other side's going to ask for time to respond.
Right.
It's going to be set over for another date for a hearing.
Right.
It's likely going to either go to that hearing or work out an agreed order at the next date. Right. So you're talking about maybe 2-3 dates.
It could be, and with the exception of the rule, if it's like to modify visitation, guess where they're going to send you? They're going to send you back to mediation.
Okay, and that won't be free.
No, that won't be free. Yep. Although
some counties are.
In Cook County, I believe, and then I believe in DuPage County, at least in the family, they have a program for in the paternity court where there's no cost. And if there is truly an expense where the people do qualify for that, they have the power to waive those fees.
Okay.
Yeah, Dave. Eric in Calumet City asks, will I have to pay spousal support if I'm only married 4 years?
Well, it really depends. There's no hardline rule on spousal support, which is formerly known as alimony, now called maintenance. The court's going to look at a number of factors. Length of the marriage is one factor. 4 years is a relatively short marriage, but it's going to depend on other things. The party's ability to make money, the lifestyle that they're growing accustomed to, earning capacity of each party, educational background. So there's going to be a number of factors. In a case like that, if it's a 4-year marriage and one party is not working, maybe doesn't have a high education level, and the other party is a breadwinner, there might be some short-term rehabilitative maintenance so that the one spouse who's not working can get back on their feet and start to be able to support him or herself. So it's hard to give an exact figure on maintenance, but 4 years is it's a possibility that there could be some short-term maintenance, I would say.
And you don't know if you don't ask. So it depends. Again, contested, uncontested. Those are things to kind of look at.
Yeah, it could be a negotiated item. Right. That's for sure.
Sure.
Camilla in Riverdale asks, I want 50% of the marital estate. How can I be sure that I don't get less than 50%?
Well, the only sure things, Dave, are death and taxes.
She's worried about disclosure issues.
Yeah.
She's worried about knowing what the other party has.
Well, the only way to do that, first of all, it depends how long you've been married. It depends on your extent and the involvement in terms of the marriage.
They have a long-term marriage.
Well, we've talked
18 to 20 years, she said.
We've talked about this before. A lot of times, one person is primarily responsible for doing the finances and paying the bills. Now, it's important for both people to know, not that somebody's hiding something, but hey, what happens if something happens to your other spouse? Not that there's a divorce or anything, but hey, something physical maybe happens that's going to require you now to do this. I've had the situation where somebody has left, and that was the person who paid the bills. Now you have somebody who's older and doesn't know how to do these things, that is learning it for the very first time. But the only way to do that is, that's why we have discovery. We have interrogatories, which are written questions. We have requests to produce, which are requests to produce specific documents. You could subpoena bank account records and financial institutions and all the things. You could do a deposition, which is after you have this stuff, you ask questions and you go through the documentation. And that's what a lot of contested cases are about. With or without children, is about the finances, and not just who has what, but who's going to pay what in terms of the debt. realistically, you could hire people, a forensic accountant, to do an investigation. Now you're talking about more and more money. If we're talking about somebody, who's you suspect has done something, or maybe somebody's working for cash.
But it may be worth it, depending on the complexity
right.
of the marital estate.
It might be worth it. Maybe you have somebody who has one of these landscaping companies, and they get cash. Well, how do you find anything out? Okay, you get the client list, and then you unfortunately have to deal with each and every individual and find out what they've paid, and if it's not reflected in there, then, and again, it's a lot of work, so you want to make sure that it's going to be financially feasible to be able to do that.
What if the spouse is the employee of the landscaping company and is paid in cash? Well, now how do you determine that for child support purposes?
Well, the court can impute income, and so you could certainly get someone to testify what an average, what a person would make, and there's a lot of different ways to go about it. But also, you could subpoena that person's records.
Or take their deposition and get them under oath.
Take their deposition. There's no guarantee
because
that
they're going to say
tell,
they're not working,
right?
And they haven't been working because they're exclusively paid in cash.
Well, then again, it comes into you're going to have to hire a private investigator to watch this person to see that they're working and to take film and video, and that all costs money.
Or bring in the owner and put that owner under oath.
All right, or subpoena the owner's records and see, because he's got a bigger problem if he's paying cash to someone who would otherwise be an employee. That means he wouldn't be paying taxes, and again, he's probably not going to want to go there.
I agree.
All right, Dave, let's see, I have Stephanie from Jolly asks, what grounds can I use if my spouse verbally abuses me, but he remains faithful?
Okay, well, verbal abuse would probably fall under mental cruelty, or irreconcilable differences at a lower level, but it depends on what he's saying. If he's belittling, if he's saying he doesn't love you, if he's demeaning, if he's saying hurtful things to the point where that's causing a hardship on you and you did nothing to cause or provoke that, I would argue that that is mental cruelty.
Well, as a lawyer, aren't you, verbally abused all of the time?
Yes. Yes.
Wow. So it could be just something as belittling.
You have to be able to handle it, though. And this is something over a repetitive nature and something going against the marriage. Someone saying, I don't love you anymore, you're fat, I don't find you attractive.
Oh, isn't truth
Again, I like Sandy at work.
Isn't truth a defense, Dave? I mean, hey, if you're
truth is a defense for
chubby
defamation.
Bubby, you're chubby.
But not in the in marital court. It's not a defense.
Okay, well, I guess I could either tell the truth or lie, right?
Yeah. But you always have irreconcilable differences.
Does this make me look fat? Right? Okay, just giving you a hard time there. Well, basically, the bottom line is that, hey, look, divorces happen. You don't have a choice a lot of times. It's better to get back and to do some counseling if you can. People have different thoughts about that. Oh, I'm going to stay together for the kids. Hey, each situation is unique, but it's important for you to be able to have the counsel and be able to have access to intelligent, competent information in order to make an informed decision on what you're going to do.
Yeah, it's always best to try and work it out.
Yeah.
Take the effort to do that. If for some reason you can't work it out and you just have an impasse, then try and work out an agreement. Because what you're going to wind up doing if you can't, you're going to wind up dragging each other down.
That's correct.
You're going to hurt the family finances. You're going to bring stress to yourself, your spouse, and your children, which you probably don't even realize what you're doing to your children.
Right.
And get some help. There's help out there. There's answers. There's solutions. There's no reason why you have to be in a legal battle for 2 years and blow tens of thousands of dollars on each side, when really that money could be better used towards your children, your family, for moving on. So that's basically my advice. See what you can work it out. Sometimes you can't.
Yeah, but at least you've tried.
Yeah. All right, Jesse. Yeah. A lot of good information there. Thanks for joining me once again.
You.
You've been watching Legal Action. We'll see you next time. Take care.